Hereby, I open this academic ceremony in which Nikolaos Papadopoulos will defend the academic thesis entitled Recharting the Judicial Enforcement of the European Social Charter at the National Level, Renew Dynamics for the Protection of Economic and Social Rights in Europe. Mr. Candidate, may I invite you to present a summary of your study and the conclusions of your thesis?
Thank you very much, Prorector. Dear members of the Assessment Committee, dear family, colleagues, and friends watching online, it is an honor to stand before you today to present my doctoral research. For the next 15 minutes, I will be giving a brief summary of the research background and problem, the research question and methodology, and the main findings of my thesis. Europe has been struggling in recent years to recover from a perpetual crisis era. One important dimension, considered to be an obvious casualty of this crisis era, is the protection of economic and social rights as human rights guaranteed in international instruments and European states' constitutions. Economic and social rights have had an uncertain status in international human rights law and in the constitutional law of most countries. Although traditionally criticized for not being suitable for adjudication by courts, in the last 30 or so years, reliance on economic and social rights is a phenomenon that has been strengthened to a certain extent. This is in line with a late turn to what has been described as the judicialization of politics and domestic judges' growing intervention in fundamental political and social questions, including on the basis of international human rights law. Nonetheless, the impact of economic and social rights is not always demonstrable in practice, as opposed to that of civil and political rights. Furthermore, modern neoliberal capitalism has questioned the manner in which economic and social rights are to be enforced and ensured in practice, particularly at the domestic level. Against this background, a once neglected regional legal instrument has come into play recently, providing a unique perspective to address many of the challenges that the protection of economic and social rights faces, both traditionally and currently. This regional legal instrument is the European Social Charter, the legally binding human rights treaty of the Council of Europe that guarantees since 1961 economic and social rights as a counterpart to the European Convention on Human Rights. The Charter, unlike the Convention, does not establish a judicial organ, but rather a treaty body consisting of experts, the European Committee of Social Rights, in charge of monitoring state parties' compliance with the social constitution of Europe, as the Charter is often labeled. Although envisaged as sister treaties, the important differences between the Convention and the Charter, as well as the structural weaknesses of the protection of economic and social rights in Europe, resulted in the Charter being overshadowed by the success of the Convention. The most important reason for the Charter's ineffectiveness lies in its lack of awareness and impact at the domestic level, and in particular, its non-justiciability. Under the prevailing view during the first 30 years of its existence, the Charter is an example of an international treaty that explicitly excludes domestic judicial review under a presumption of non-justiciability. In other words, the Charter did not create individual rights, but merely programmatic principles, which required positive action by the legislator for them to become operative. Near the end of the 20th century, a revitalization process was initiated, which led in 1995 to the establishment of a collective complaints procedure, enabling social partners and NGOs to lodge complaints directly to the Committee of Social Rights about the conformity of a state party's law or practice with the Charter. Furthermore, in 1996, a revised version of the treaty was adopted to address the social changes that had taken place since the adoption of the original Charter in the 1960s. This evolution in the Charter system has been regarded as a powerful incentive for individuals to invoke their Charter rights before domestic courts. The 2008 global financial crisis has also resulted in the domestic courts regularly facing the question of applying the Charter to review the choices of the legislator in their respective jurisdictions. However, unlike other human rights treaties, there has been no systematic analysis of the Charter as interpreted by the Social Rights Committee vis-à-vis its judicial enforcement and impact at the domestic level, in view of this revitalization process and the developments of the crisis jurisprudence. Therefore, the Charter's dynamics for the effective judicial protection of economic and social rights at the national level remain uncharted. The primary objective of the thesis is exactly to address this research gap by posing the following research question. To what extent does the Charter, as interpreted by the committee, contribute to the judicial enforcement and the protection of economic and social rights at the national level? To answer it, the thesis was divided into three separate parts. Part one of the thesis should be regarded as a preliminary step for the rest of the analysis. It is based on doctrinal descriptive legal research that discusses, under an international law lens, the Charter's applicability by domestic courts. At the same time, it inquires into the legal effects of the committee's pronouncements, especially its collective complaints decisions. Part two is based on comparative human rights law research. By using a functional approach, it compares among 5 selected jurisdictions that are fully committed to the Charter system, the status of the treaty in domestic law, and the judicial approaches of the selected parties' supreme and constitutional courts to the application of the Charter as interpreted by the committee. These 5 countries are France, Greece, Italy, the Netherlands, and Spain. Finally, part 3 of the thesis is based on doctrinal descriptive legal research that draws inspiration from a case study design. It provides insights into the influence of the Charter, as interpreted by the committee in its recent jurisprudence, on the practice of the higher, but also predominantly on the lower domestic courts of the selected jurisdictions, as well as on their law and policy. These cases concentrate on Greek and Spanish austerity measures, the Dutch policy on the reception of undocumented migrants, and Italian and French reforms on the law of dismissals. Let us now turn to the main research findings of the thesis. In part 1, I examined in detail the old position that the Charter precludes individuals from invoking the treaty before national courts and the latter from applying it. As demonstrated, this position cannot stand today. The application of the Charter by domestic courts, either in vertical or in horizontal disputes, is in principle possible even where no implementing legislation has been enacted. Furthermore, the fact that the committee's decisions are not legally binding does not mean that they cannot produce legal effects, which could be of decisive importance for the interpretation of a Charter provision. Therefore, the prima facie limited effectiveness of the committee's decisions could be overcome through the affirmation by state organs of the quasi-judicial characteristics of the collective complaints procedure and the quality and persuasiveness of the committee's interpretive work. The analysis in part 2 has revealed that since the outbreak of the 2008 global financial crisis, the visibility of the Charter and of the committee's decisions across the higher courts of the examined jurisdictions was strengthened. Nonetheless, applying the Charter does not necessarily mean that the committee's interpretation is authoritative or even relevant for the adjudication of the case by higher judges, as the findings show. Moreover, the spotted differences in the judicial application of the Charter between the selected states should be attributed not to the particularities of the Charter as an economic and social rights treaty, but to various legal as well as extra-legal characteristics or factors that are exclusive to each examined jurisdiction and require further attention. In terms of the identified similarities, highest domestic courts are more inclined to apply economic rights provisions of the treaty or rights that are also enshrined in treaties guaranteeing civil and political rights, such as the Convention on Human Rights. This could well be an indication of higher judges' persistent hesitation to apply social welfare rights provisions of the Charter, especially in crisis-related cases, for separation of powers or for other reasons related to the understanding of the nature of social rights under the respective jurisdiction. In any case, the direct effect of the Charter is now predominantly assessed by the domestic courts on a case-by-case and provision-by-provision basis, while the presumption of non-justiciability that has traditionally been attributed to the Charter has been rebutted in practice. As demonstrated in all case studies of Part 3, since the outbreak of the financial crisis, lower courts have proved even more receptive to the application of the Charter than higher courts. Additionally, national courts have provided high degrees of legitimacy to the Committee by recognizing the sound argumentation of its decisions. Finally, in the cases discussed, it has been demonstrated that where economic and social rights protection under the Constitution and other international or supranational sources proved inadequate in the face of austerity or other restrictive measures, the Charter served as a minimum tool of effective protection for poor and marginalized groups of people through its direct or indirect application by domestic courts. Therefore, as the findings have shown, the Charter, as interpreted by the Committee and as enforced by domestic courts, has an important added value for the protection of economic and social rights at the national level, where most such rights are considered as mere principles, ultimately dependent on the legislator to be given effect. The Charter has provided significant impetus in the examined jurisdictions for an effective treaty-based review of domestic legal provisions to be conducted by domestic courts, while facilitating the adoption of novel methods of judicial scrutiny of economic and social rights without upsetting the political balance. In addition, important labor and social issues have been considered in public debate by individual and collective actors, especially politically underrepresented groups, and changes in law and policy have occurred on the basis of the Charter. The increased recognition of the Charter as a justiciable treaty by domestic courts has also been of decisive importance for the treaty's implementation at the national level as of late. Moreover, the Committee's jurisprudence has been a significant factor in shaping domestic interpretation of economic and social rights. The recent judicial enforcement of the Charter, as interpreted by its monitoring body, refutes the misconception that economic and social rights are represented in the Charter's provisions as mere legislative policy objectives of the contracting parties that require extensive positive conduct and resource commitments. Rather, at least some of them should be seen as justiciable and enforceable, at least to a certain extent, rights of subjective or objective nature, corresponding at times to immediate and precisely delineated positive or negative obligations of the state. Additionally, when given due attention, the Charter and the Committee's decisions could act as a forceful public opinion instrument for individual and collective actors advocating at the domestic level, thus also enhancing their democratic participation. Nonetheless, the effectiveness of mobilizing the Charter is largely dependent on the labor movement and civil society dynamics in its jurisdictions, as well as on the acceptance and visibility of the collective complaints procedure, which has yet to be strengthened. The relatively low number of ratifications of the optional collective complaints protocol undeniably reduces the Charter's effectiveness at the domestic level, thus potentially creating a two-speed system of economic and social rights protection in Europe. Overall, this thesis contends that the Charter's structural complexities and limitations, or the absence of a monitoring mechanism that leads to a binding judgment by a judicial organ, should not be seen as an impediment to the treaty's effectiveness, unlike what is frequently argued. Despite the weaknesses of the Charter system, the revised treaty and the rich jurisprudence of the Social Rights Committee, as well as the recent examples of the treaty's influence at the domestic level, have laid the groundwork for the treaty to exit the shadows of the past and become a reliable and potentially effective human rights instrument for the realization of economic and social rights. Therefore, the findings with respect to the examined fully committed jurisdictions provide an original example of the Charter's current role and potential in rectifying in practice many of the common misconceptions about the nature of economic and social rights and the role of the judge in enforcing them. In conclusion, in the current situation of a perpetual crisis in Europe, in which economic and social rights protection remains under subversion, the European Social Charter has recently started to emerge at the pan-European legal level as an important point of reference to address many of the challenges of the social question of our times. With this, I thank you for your attention, and I look forward to our engaged discussion. I hereby give back the word to the Prorector. Thank you.
Thank you for your presentation. The opposition will be opened by Professor Klaas. Professor Klaas is Professor of European and Comparative Constitutional Law at our university, and she is also the chair of the Assessment Committee.
Thank you, Mr. Prorector. Dear candidate, I would like to begin by complimenting you on an excellent thesis. Your book, in my view, gives a very good account of the dynamics between the European Social Charter and national legal systems, and of the contribution of the ESC and the ECSR to the enforcement of social rights. It gives proof of solid knowledge and deep understanding both of the more general issue of domestic application of treaty law and of the Charter specifically. The level of detail of the analysis is impressive, and the comparative research you have conducted is very well done. The choice of countries is convincing, and you seem to feel at ease in all of the various systems that you have reviewed. So, congratulations on this. But then a question. My question relates to your comparative work and to the conclusions that you draw from it. In the comparative conclusions of part 2 of your book, you seek to explain the differences and the similarities that you have found in the way that the Charter and the interpretations of it by the committee are used by national courts. So, namely, to what extent they consider, these national courts consider the provisions of the Charter justiciable. You have found similarities, but also variation in the approach of national courts, and to a large extent you claim these variations are due to the manner in which direct effect is embedded in the legal system and is applied by the courts. And you also point to concerns, to the status of pronouncement of the committee in the Constitution. You also point to legal factors that, as you say, are unique to each jurisdiction. For instance, the powers of national courts to conduct treaty-based review of national law. And you rightly also point to the differences of political will in the various countries to take the commitment to the Charter seriously. And I find your findings entirely convincing, but I would like to push you a little bit on this. Could you indicate what conditions in the legal system, so in the legal infrastructure, make a system most apt for the Charter to be considered justiciable and to be used by the courts to achieve social change? So does monism, dualism play a role? Or, for instance, the text of the Constitution? Or whether or not social rights are recognized in the national Constitution and are already justiciable? Or perhaps also the conception of the role of courts in issues of redistribution. So in short, what national legal environment is most apt for the Charter to be used judicially to achieve social change?
Highly esteemed opponent, thank you so much for your kind words and for your intriguing question. Indeed, in my research, in my comparative part, which is part 2 of the thesis, I engage in a comparison of 5 countries that are fully committed to the Charter system and which have differences and similarities, which I indicate. And the fact that they are fully committed does not mean that they do not have structural differences in terms of how they apply international and national law, the relationship between those 2 systems, but also the way they apply economic and social rights in their constitution, how they recognize them, and what powers domestic courts have in order to apply them in judicial cases. In my view, all countries have mixed structures and mixed characteristics in terms of the relationship of international and national law. We see that although in theory a state might be monist, in practice the domestic courts might be using avoidance techniques that lead to the application of international law being in a closer relation to the dualist side of the spectrum and not to the monist side of the spectrum. In addition, we have states where they are in principle possible that the application of international law is not possible in a direct manner, for example, dualist states, but we see that in practice, the way that they incorporate international law and the way that domestic courts apply international law in their decisions resembles more the structure of a monist states. So I'm not saying that I'm trying to show in my thesis that it doesn't really matter what the status of international law is in national law and what is the culture in this country or what is the choice of incorporation, but it's more of some structural factors that have something to do with this. And these structural factors are first the competence of domestic courts in directly applying international human rights treaties, and the manner of conception of the direct effect doctrine, which differs from each state, the enshrinement of economic and social rights in the constitution or in the culture of a state, and also the subjective criteria, or if you wish, the informal criteria of the subjectivity of the interpreter, the culture as regards the international and human rights law in this country, and informal factors such as the linkage of international courts and judges in particular with international networks, or the position of the court. It might be positioned in a place of the country where there is no much information, or there are no databases where domestic judges can have some information about international law, international commerce, or even in the curriculum of legal schools in the country. I hope this has answered your question to a degree.
Then the opposition will be continued by Professor Stangos. Professor Stangos is Emeritus Professor of European Union Law and European Human Rights Law at the Aristotle University of Thessaloniki, and also a member of the Assessment Committee. And I would like to welcome him very much to Maastricht University today. Very good to have you. You have the floor.
Thank you very much, Mr. Chairman. First of all, thank you for the invitation to participate to this assessment committee. Congratulations to the candidate for his work, and also the congratulations for the supervisors of the thesis. As I noted in my written contribution to the assessment of the thesis, with this thesis, it is the first time that a scholar shows so clearly that domestic jurisdictions are able to become the channel through which the norms of the Charter, as interpreted by the European Committee of Social Rights, are effectively applicable in the domestic legal orders and consequently influence the corresponding economic and social policies. My question is the following. Is there a risk through the intervention of domestic jurisdictions in the application of the Charter, an intervention that will be carried out in concert with the authoritative interpretation of the Charter by the Committee? So, is there a risk of distorting social rights as they are understood by the Charter and the system of collective complaints? Why I put this question? First of all, on the domestic level, we have actions brought by individuals, and on the other hand, at the transnational level, in the European level, the essential purpose of the collective complaints system, as you rightly acknowledge in your thesis, is to compel states to act in conformity with the Charter by means of their legislative power for the benefit of the whole population, for the benefit of the community. After all this, let me summarize my question. Is there a risk of altering social rights? Is there a risk that through the intervention of domestic jurisdictions in their application, they will lose their character as rights at the service of the community? If there is such a risk, are there ways to avoid it?
Highly esteemed opponent, thank you so much for your question. It is a very thoughtful question, really intriguing. And in my research, I would not say that I totally deal with this issue, because what I'm trying to show is the manner through which domestic courts apply the Charter, if they do, and if they avoid the Charter, how they do so. So I'm trying to show a generalizable conclusion about the enforcement of the Charter, which remained a terra incognita in the legal doctrine. So my question is about the ways that domestic courts apply the Charter. I do not go into these details, which are really, really intriguing. So I will try to answer your question in the best way that I can. The collective complaints procedure is a procedure that has been accepted by a minority of states of the Charter. So the committee's decisions that bind those states could be a source of inspiration for domestic courts when they apply the Charter as interpreted by the committee. However, being a collective complaints procedure, it has many collective it has a collective structure, and its target is not the individual, so individual justice, but it's more of the law and policy of the Charter and bringing it, of the treaty, of the state concerned, and bringing it into conformity with the Charter. So when domestic courts apply the European Social Charter, and this has nothing to do with decisions of the committee and the way that they are structured by the committee, but when the decisions come into play, and this is where social partners and NGOs have a role to play as political, let's say, participants in this procedure. This allows the individual to show cases in which the domestic law or practice of a state is not in compliance or breaches the Charter. So I would not say that an individual cannot find individual justice through the decision of the court, which could then lead, as I have showed in my thesis, in political changes or in advocacy by domestic NGOs or civil society and labor movement structures in the country. And this could have an effect for the whole population. But also the way that domestic courts apply the Charter does not mean that this jurisprudence is based on the individual only, but also it has to do with the conformity of a state's law and practice with the Charter, which could indirectly have an effect on the way that the legal doctrine, other courts, higher courts in the same jurisdiction, or the state and its authorities conceive economic and social rights, apply them, and bring their legislation and practice into conformity with such standards. So I'm not really sure whether social rights jurisprudence on the basis of the Charter is distorting economic and social rights, but rather it is promoting economic and social rights at the national level, and the collective dimension of economic and social rights could still be protected through this adjudication process. I hope this answers your question.
Are you satisfied with the answer? Thank you so much. In that case, the opposition will be continued by Professor Elkinate. Professor Elkinate is Professor of Human Rights Law at University College London and also a member of the Assessment Committee. And I would like to welcome him also very much to Maastricht University today.
Thank you, Mr. Pro-Rector. It is a great honour for me to be here. I would also like to join my fellow colleagues on the opponents panel in congratulating the candidate for an original and superbly well-written, argued and referenced thesis. It was a pleasure to read something that was so readable, all the more so for me as a native speaker. It is sometimes you struggle, sometimes the thesis is written in candidates' second, third, fourth languages, but this was a real credit to you and a model of the clarity of your thought and organisation of the material. However, as always, I have a question for you. You say that you are adopting, in discussing your methodology, you say you are adopting a legal positivist approach based on a traditional doctrinal analysis. I wonder whether in this context it provides, this approach can provide sufficiently clear answers to the questions you are addressing, not least because many of these questions such as whether the case law of the European Committee on Social Rights is sufficiently clear to be given effect within national law. Many of these questions don't lend themselves to very easy yes or no, right or wrong answers. So given that context, can a traditional positivist doctrinal methodology such as you adopt, can that really give us the clear answers that you are looking for in your work? Thank you.
Highly esteemed opponent, I am most grateful for your questions and your kind words. Indeed, in my thesis, I adopt a doctrinal legal research lens. I am entirely based on legal coherence and legal certainty, because the objective of the thesis and my goal was to show exactly to what extent domestic courts apply the Charter and to what extent does this application of the Charter by domestic courts contribute to the judicial enforcement and the protection of economic and social rights at the national level. Of course, your question does not have a clear answer as well. So I will try my best to answer it by including other approaches, interpretive approaches, to my findings. And this is exactly what I tried to do also in my thesis. I tried to show these legal, structural, and formal characteristics of the domestic legal orders that have an influence, that have a say on how the Charter is applied at the domestic level. And by pointing out those structural elements within each jurisdiction, we can put aside those factors that are informal or that have an influence of the Charter but cannot be researched with doctrinal methods, and you need an extra legal, socio-legal, or empirical research lens to find them out. And these elements are, of course, leading to do research on the status of the individual and his or her relationship with the application of economic and social rights. I have tried to show the position of the individual in my research. For example, whether the application of the Charter by domestic courts depends on the profession of the judge before becoming a judge. For example, whether he was a university professor or whether he has sufficient knowledge of the economic and social rights protection system in Europe. But also the role of lawyers, how they engage with the Charter system, how they advocate at the national level, and so is the case with NGOs and trade unions. And this could have an impressive influence on the application of the Charter at the national level. But this was only mentioned in passing in my research because, of course, this would need a different research question. It would not show the extent to which the Charter is applied, but why is the Charter applied, and which are these informal characteristics that play a role, but not only with the Charter, but also with other international human rights treaties, as well as economic and social rights at national level, as enshrined in constitutions. So my goal was to separate these issues, these formal legal aspects, and try to show whether they do have an influence. And I believe that by looking at various countries that are fully committed to the Charter system but have differences, both in terms of culture, but also in terms of how they understand the relationship between international and national law, I could provide an answer to the dynamics, to what the dynamics of the Charter are, and how there is a development compared to the past. And this has to do also with the influence of the committee's work, the European Committee of Social Rights work, and of course the global financial crisis, which had an impressive impact on domestic judges. And their decisions are well-reasoned and based on the committee's interpretation. And this is a legal element which I believe can definitely show clear answers about the application of the Charter at the national level without having to engage in non-doctrinal methods.
Are you satisfied with the answer?
Yes, thank you.
Thank you so much. In that case, the opposition will be continued by Professor Klosse. Professor Klosse is Professor of Social Law at our university and is also a member of the Assessment Committee.
Dear candidate, first of all, I would like to join my colleagues in their compliments for your book. In my view, you succeeded very well in casting fresh light on the judicial enforcement of the European Social Charter. What your research clearly demonstrates is, for example, that the jurisprudence of the European Committee of Social Rights is increasingly used by domestic courts to shape the scope and the content of the Charter's provisions as justiciable and enforceable human rights norms. This is, of course, very good news for the protection of the rights enshrined in the Charter. It even seems to bring you a bit in an euphoric mood at the end of your book, where you conclude that the Charter in its current form has the potential to serve as a reliable tool to overrule neoliberal and market-dominated approaches, and could even become the pillar upon which the European social model can be grounded and further developed. As a professor of social law, I really like this prospect. But I cannot help wondering whether you are not a bit too romantic here. Does your study really support this appealing prospect? In my view, there are reasons to doubt that. For example, because producing legislation which is based on neoliberal or market-oriented views is part of a state's policy. So if lower courts find violations of the Charter, it's quite likely that national governments will appeal against such a decision, for example, because of the policy changes that corrective measures may require and the financial consequences thereof. Your study shows that in this process, national governments may find higher courts on their side. Especially when political sensitive issues are at stake, higher courts are inclined to rely on the principle of separation of powers in order not to trespass the domain of law and policymakers, even if this may be at the expense of the effective protection of the Charter's rights. Illustrations of this can be found in your comparative chapter, where you rightly note that the Dutch Supreme Court has not shown great enthusiasm so far in affirming direct effect to the Charter's provisions. The same seems to be true for Spain, whereas in Greece, the latest stance is a regressive one. A similar trend can be detected in France, where the Supreme Court, after an upswing, lately reverted to a more modest approach. This defensive attitude can have a serious inhibiting effect on the full realization of economic and social rights, regardless of the progress made in the recognition of the justiciability of the Charter's provisions by lower courts. Your research does not seem to provide an answer to the question how this practice relates to your final statement about the Charter's potential to become the pillar upon which the European social model can be grounded and further developed. There seems to be a contradiction here, so maybe you can elaborate a bit on this now.
Highly esteemed opponent, many thanks for your intriguing question. Indeed, your question embodies the whole conflict that exists in the legal scholarship between economic and social rights and their protection by domestic courts, and the issues of democratic legitimacy of national courts in applying economic and social rights, which have for many years been seen as requiring extensive positive conduct and research commitment by states, as well as the institutional legitimacy of courts to apply economic and social rights and trespass on the domain of the legislator, but also the conflicting relationship of economic and social rights as they are enshrined in national constitutions, which were created in the 20th century, or international treaties that were adopted in the mid of the 20th century, with modern neoliberal capitalism and the role of the welfare state and the social state principles in our globalized legal orders. I will focus more on my thesis and not on this whole doctrinal question and the criticism, because this is exactly the basis on which my research is grounded. I tried not to focus much on theoretical aspects of the justiciability and enforceability of economic and social rights, taking for granted some of the fundamental legal research that has been done on the relationship of economic and social rights with the economy and with the separation of powers principle. But in my research, and this is also shown in some of my parts, as you mentioned, in some of the parts of the research, as you mentioned, because the courts may not be explicitly saying that we're not applying the Charter because of separation of powers reasons, but they are providing avoidance techniques to address exactly this issue, especially in crisis-related cases. And this is what I tried to emphasize, because when the application of economic and social rights, as enshrined in the Charter or in national constitutions, is conflicting with the with important policies and they have a role to play in the economy, this is exactly where higher courts tend to show a defensive stance and not apply economic and social rights. In other cases, however, we see that where the higher courts adjourn in section, in formats of law of fewer judges than in plenum, we see, and where the not important issues in terms of the state's economy or finances are concerned, they are much more positive in applying economic rights and employment rights provisions of the Charter, or rights that are also enshrined in the Convention on Human Rights, in the Charter of Fundamental Rights, and in the national constitutions. And this is exactly where the position of the Charter comes into play and brings an added value to the protection of economic and social rights and to the development of a European social model. So not entirely directly, because the Charter does not have the visibility of the constitutions or the Charter of Fundamental Rights of the EU or the Convention, but indirectly it serves as a source of influence for the Charter of Fundamental Rights and the interpretation of economic and social rights provisions enshrined therein, or due to the relationship that the Charter has as a sister treaty to the Convention and the similarity of many of the provisions, for example, the right to organize, the right to work, or the right to collective bargaining. And through the indirect application of the Charter by courts, or through the enhanced visibility of the Charter across higher judges, but also other state organs, the Charter could provide a solid influence on the development of the European social model by showing how economic and social rights can be justiciable, they can be applied by domestic judges without upsetting the political balance, they can enhance the democratic participation of some poor and marginalized groups of people, either through litigation or through advocacy. And of course, we're not discussing about economic and social rights becoming immediately enforceable rights. Of course, this would be contrary to many principles of our legal systems. But we are talking about providing checks and balances for the judge to take economic and social rights into account in their decision as human rights. And this is a matter that has not really been dealt with, because we usually see economic and social rights discussions focusing on the matter of economic and social rights as social policy principles only, and not as human rights, whereas they are explicitly protected as such and have a protective function, not for the higher, in my view, for the lower income employees, for the socially marginalized groups of people, and those who need the protection the most. How does this answer perhaps your question? Thank
you. The opposition will now be continued by Professor Sillen. Professor Sillen is Professor of Constitutional Law at our university, and he's also a member of the Assessment Committee.
Thank you, Mr. Prorector. Dear candidate, it was with great pleasure and admiration that I read your interesting book. It offers a well-written analysis of how the European Social Charter and the decisions of the European Committee of Social Rights affect the legal orders of 5 European states. I learned a lot from it, especially since you have managed to draw on case law and literature in the original language, and have not limited yourself to the case law of the highest courts, but also included that of the lower courts. Moreover, you explicitly pay attention to the socio-political context of the various judicial decisions. As a result, your book offers a fine, comprehensive, contextual analysis of the application of the European Social Charter. You have delivered an achievement to be truly proud of. My question is about the effect of international law in the national legal order. In your book, you argue, on the one hand, that national law determines whether treaties have direct effect in the national legal order and, more specifically, can be invoked before national courts. You call this the traditional view on page 68. On the other hand, you note that several scholars argue that this question of direct effect and invocability cannot be answered solely on the basis of national law, but must also involve international law on page 67. I call this the modern view. You yourself do not clearly choose between the traditional and the modern approach. This leads you to note, on the one hand, that direct effect is a question of national law on page 304, and thus to follow the traditional approach. On the other hand, you describe decisions of national courts that distinguish between treaties with socio-economic rights and treaties with political rights as outdated. And you argue that national courts should assess the direct effect of treaties contextually, that is, in light of the case at hand, rather than solely on the basis of the text of a treaty provision. With these statements, you seem to adhere to the modern approach. So my question is, where do you stand in this debate? How should the direct effect and invocability of a treaty be assessed? Is that a question of national law, or also a question of international law? And why? In short, are you a traditionalist or are you a modernist? And know this, modern is not always better. I'm looking forward to hearing your response.
Hi, and thank you so much for your question and your kind words. Indeed, I would say that I am a traditionalist, but also a modernist at the same time. So indeed, in my research and in the first part of my research, where I lay down the doctrinal views on the relationship between international law and national law, I do not explicitly take a stand on whether giving direct effect to a treaty provision is indeed a question of national law or international law. I just point out the traditional view, as you mentioned, and the opposite view, the modern view that has been developed in recent years. However, in part 2 or part 3 of my thesis, where I discussed the application of the Charter by domestic courts, I think I give a hint on where I stand in this debate. And just to be clear, my view is that, of course, the direct effect of a treaty provision must be assessed by domestic courts on the basis of national law. However, given the fact that national courts deal with international treaties and provisions of international origin, it's wise to look into the interpretation of the interpretative principles as enshrined in the Vienna Convention on the Law of Practice in order to interpret an international treaty provision, and thus also look at the interpretation of the monitoring body of this treaty in order to find out what the content of these obligations that are enshrined in the treaty are. So in my view, there is definitely a matter of international law in this assessment of the courts. Of course, they use the techniques that they are given from national law in order to assess whether a treaty provision is directly effective, the objective, the subjective criteria, etc. But in my view, it would be most beneficial for the domestic court to look into international law in order to have a grasp of what the treaty is about, how it should be interpreted, with what legal techniques, and what does the authoritative body, in this case the Committee of Social Rights, has to say about the interpretation of this provision. And this could provide a definitive solution for the case, for the judge at the case at hand. Now, as concerns the second part of your question, where you mentioned that I considered the jurisprudence of domestic courts applying economic and social rights in a restrictive way as outdated, I would have to say that in terms of their application of the Charter, Following the revitalization process of the Charter and the establishment of a collective complaints procedure, and looking at the rich jurisprudence that the committee has produced, but also looking at the way that domestic courts are increasingly applying the Charter, this, in my view, shows that indeed the approach of some courts regarding economic and social rights is outdated in the sense that it do not take into account the developments at the international level regarding this treaty. A domestic judge should not only look at the legal system, of his legal system or her legal system, to provide an answer to a question, but also look at how this treaty is structured, if it addresses individuals, if the subject is the individual, and also the interpretive practice of these monitoring bodies that monitor compliance with the treaty. So in my view, this is not a black or white answer if the jurisprudence is outdated, but for some instances, in my view, they could be identified as outdated because they simply reject the Charter or the economic and social rights provision at hand without delving into the substance of the content of the treaty provision at hand, or the interpretation of a treaty monitoring body, the authority of which they have explicitly accepted. And in this case, we are talking about 5 states that are fully bound by the Charter. They do not wish to have any margin of appreciation regarding the acceptance of the Charter. They have accepted the collective complaints protocol, and they fully collaborate in good faith with the committee. So, I hope this answers your question. Thank you.
In that case, the opposition will be continued by Professor Imamovic, who is Assistant Professor of Human Rights Law at our university.
Thank you, Mr. Prorector. Dear candidates, let me also start by congratulating you on this very interesting book. I think it's very well researched and written, and I've really enjoyed reading it. My question is about potential accession of the European Union to the European Social Charter, which could be seen as a perhaps desirable step considering the large number of areas covered by the European Social Charter in which the EU has been attributed powers by the member states, as well as the potential for further legislative instruments to be adopted in these areas. Accession to the revised European Social Charter could also extend to the additional protocol on collective complaints, and this is something that the European Parliament has expressed itself to be in favor of and has called for already since the 1980s. So my question is, to what extent do you see this as a step further in increasing the visibility and promoting economic and social rights at the member state level in the states that you have researched, but also more broadly, a more social Europe? And in that context, I wonder if you envisage issues with the constitutional setup of the European Union, similar to those expressed in the context of EU accession to the ECHR by the Court of Justice.
Esteemed opponent, I am most grateful for your question. Indeed, you raise a very sensitive issue, which, if we were talking about the Convention on Human Rights, there would be much more debate. But because we're talking about the Social Charter, at the time, we're not really questioning whether the EU will accede to the Charter, and I will explain in a minute why. Of course, given that the EU has not even acceded to the Convention, and there are many institutional problems in that regard, you can imagine, and we can all imagine, that there could be even more structural problems if the Commission would even consider acceding to the Charter. Indeed, the Parliament has raised the discussion as early as 2014, if I'm not mistaken, about accession to the Charter, but there are indeed many institutional and structural problems. I will begin by pointing out the institutional problem that relates to the fact that some member states of the Council of Europe have not even ratified the revised European Social Charter yet. They are still bound by the original Charter. Only a minority of these member states has ratified the collective complaints protocol, although there are 4 or 5 member states that have signed the protocol and have not ratified it yet. But this is just really a minor issue regarding the potential conflicts of potential EU accession to the European Social Charter, and in particular the revised European Social Charter. On the one hand, the European Union has a different mindset when it comes to economic and social rights. this has been also shown in the jurisprudence of the European Committee of Social Rights, most prominently in the Laval case, which afterwards led to the to a collective complaint by a Swedish trade union to the European Committee of Social Rights, where the committee took the exact opposite direction of the court than the Court of Justice, and this comes to show that there is no. The committee is not intending to show that compliance with EU law could mean that there is also compliance with the Charter. This could raise many problems, and this is also something that many member states have pointed out, and they are concerned with their, the fulfillment of their obligations under EU law, but also under the ECHR at some points, and their compliance of their national law and policy with the Charter, which could be sometimes conflicting. However, there is always a bright side on this, and as I tried to show in my book, the Charter could provide influence, and it has already provided influence in the renewed dynamics which are developing in the European Union following the financial crisis and the implications of the COVID pandemic in the social field. For example, the directive on adequate minimum wages in the EU has an important place for the Charter or for ILO conventions, and this is exactly in the new legislation that could be passed in the future by the EU, which has recently started to show a more social face in terms of providing new legislation, where the social charter could have an indirect but extremely significant influence on how economic and social rights could be shaped, could be interpreted and applied at the national level, but also at the European level. However, the matter of the interpretation of the committee and in the conformity of this interpretation with EU law and the EU standards is a really hot topic that needs to be recognized both in terms of EU and the terms of the Council of Europe. And this is exactly where the interaction between these two organizations has been taking place in recent years, following the so-called Turin process, and especially how those two legal systems and those two organizations can come together as one in the social field. And I think there is much more to say about this in the future in terms of EU law and the European Social Charter.
Dear candidate, the time appointed for defending your thesis has passed. The Decree Committee will now withdraw to discuss the quality of your thesis and the quality of your defense. And I request that you and your company will await the results of our deliberations and our return in this room.
Please all rise.
The PhD defense has now ended. The Degree Committee will debate the candidate's performance behind closed doors. This process usually takes about 10 minutes.
Long road to the south side. 10 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and die. All your time, 'cause I'll go the extra mile. Long road to the south side, 10 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer. East side to the west side. No place like home. If it's questions that you've got, go the extra mile and die.
On the dash, got my laces tied. Long road, I don't waste no time. Break rules because fate decides. With the team and we chase the light. I make a move, fall down, shake it off. I hate to lose, bad branch, break it off. No room for negativity, praise and love. Prepare for deep part cause we're taking off.
Get the mileage, traveling so far from home. Gathering knowledge, other connections. I put the time in to get everything I ever hoped for. It's a challenge and we all in. It's a better future that we go for. And even though these nights seem long, I know that I am never on my own. Know you won the battle once you've grown. South side, 10 miles in my rearview mirror. I know what it felt like. My goal's only getting clearer. East side to the west side. No place like home. If it's questions that you've got, go the extra mile and die. Long road to the south side, 10 miles in my rearview mirror. I know what it felt like. My goal's only getting clearer. East side to the west side. No place like home. If it's questions that you've got, go the extra mile and die. Years can't fly by now, don't waste all your time. Cause I'll go the extra mile.
Nikolaos Papadopoulos. The degree committee here present has assessed the quality of your thesis and the quality of your defense. In view of its positive verdict and taken into account your previous qualifications, the degree committee has decided to grant you the degree of doctor. Professor van der Meij is authorized to confer upon you this academic distinction in accordance with Dutch university custom. And I now invite your supervisor to take the floor.
Do you promise to work in accordance with the principles of scientific integrity at all times? To be careful and honest, transparent, independent and responsible?
I promise.
By the authority vested in us by law and in conformity with the decision of the committee here present, I hereby confer upon you, Nikolaos Papadopoulos, the degree of doctor and grant you all rights attached by custom and law. As evidence of this, I now present you with the degree certificate signed by the rector, the secretary and the other members of the committee and affixed with the official seal of the university.
So it's my honor to be the first person to address you as Dr. Papadopoulos. Dear Dr. Papadopoulos, dear Nikos, I'd like to say a few words just to congratulate you, of course, for what you did, for a special trajectory. I think the trajectory on this thesis must have started when you were a master's student here a few years ago. And I do remember a session I had in my course on the protection of social rights. It was at the time when this was a hot topic, particularly in your country, I guess, but also elsewhere in the context of the austerity measures following the Euro crisis. And I still remember that you, but also some of your compatriots who were also in the class, had a really strong interests and strong views also on the matter. And I could see how you got interested in these topics. And then this led also to your master thesis, which was on a topic in this area. And after that, you approached me saying, well, I would like to write a thesis, a doctoral thesis on this. But I'm going back to Athens because I have the law firm waiting for me. And so that's what we did. And so a few years later, about 5 years later, I don't know how long ago this was, 5 years about?
Four and
a half, yeah, only. You're here, you're here with this book which has been praised by the members of the committee for being an excellent piece of work, and of course we agree with that. And it's been remarkable because you did that as a so-called external PhD student. So unlike most doctoral students at this university, at most universities, you were not based here. You were not given a little salary to spend time on your research, or most of your time on your research. Instead, you had to do it alongside your main job, which was that of being a practicing lawyer in Athens. And so in many cases, in situations like this, after the initial enthusiasm, the candidate struggles, to combine daily work with writing on a thesis, in isolation also, I should say, so far away from other people who are in the same situation. You have to find, your own discipline to keep working on this project just on your own, with supervisors being very far away. So in many cases, it doesn't work well. In your case, it worked wonderfully, in the sense that the ones who were put under pressure were us, actually, because you kept sending us chapter after chapter. We never had to ask you, where's the next chapter, because we got it. You had to ask, no, you didn't really, but you were wondering, when do I get the comments now on this chapter? But you eventually got the comments, And unfortunately, because of the COVID situation, we couldn't physically meet enough, I think, during the time. So the plan had been originally that you would come regularly to Maastricht to discuss your thesis, and that wasn't very easy. So we had to do a lot of online, but it went all really, really in a very smooth way. And we had interesting exchanges, but you did this work basically by yourself, and you worked on a new topic, which, as was already mentioned this afternoon, hasn't been documented enough. You know, the way in which national courts work with the European Social Charter. I think you were also a little bit lucky in the sense that during the time of your defense, things happened. You know, that there was more and more courts in countries that started to do things with the European Social Charter. So that was nice in a sense. You also innovated in another way, namely in your method of research, because when you actually proposed to look at 5 countries, I think our first reaction was to say, okay, that sounds good, but do you actually read Dutch judgments and Spanish judgments and Italian judgments? And you said, no, I don't read these things. I said, so okay, so how are you going to do it? But you did, because you had this wonderful translation program, which manages, apparently, to translate faithfully, you know, legal texts, judgments mostly, but legal texts in generally, in a very accurate way. And of course, I checked a few times, you know, when you cited from a Dutch judgment of the Dutch Supreme Court, I went back to the original and said, okay, is this right? Yes, it was right. And so, for me, this was also new, because when I did comparative work, you know, in the old days, you could only study the countries whose language you could read. That's it, you know? There was no other way, or you had to rely on secondary sources. Whereas you showed how you can effectively, actually, get to grasp and to understand, actually, what happens in countries like Spain, like France, like Italy, the Netherlands, and see what's going on there. So that also from that perspective, I found it's a really interesting experience for me. So now here you are with this thesis, which has been praised by the members of the committee in their reports, but also today when we discussed your defense, everybody said, no, this was a really good piece of work, good defense. So all my congratulations to you and to your company, to your parents who are here also. So it's a really a remarkable thing that you've done. Congratulations.
Thank you so much.
Bye-bye.
Thank you for everything.
Dear Dr. Papadopoulos, also on behalf of Maastricht University and its Faculty of Law, many congratulations on the degree you just acquired. As I understand, it's your second degree of our university, but it's the highest one we have available. So that is really good. Congratulations to you, also to your paranymph, your one paranymph, and to your family and friends present here and watching this ceremony online. Please do celebrate today. I still have one practical remark to make, which is that we are going to take the traditional photo of the young doctor together with the supervisors and the paranymph and the entire committee on the stairs of this university building. So we will go there in a minute. And after the taking of that photo, there will be a reception that is hosted by you right here also in this building, to which everyone present here is very much invited. And with this, I close this academic ceremony.